Good morning, sir. You went for Lamont? And Mr. Lamont, Mr. Fitzgerald is here on behalf of Mr. Chandler. You're charged with evading arrest or detention with previous convictions and unauthorized use of vehicle. And Mr. Fitzgerald, what is the amount? See that one of the cases is a little newer, but where are y'all on discovery or? All right. So what I'm going to do, Mr. Fitzgerald, is this will be. I'll reset the case one more time. This will be the final reset. So you need to get with Mr. Chandler, figure out go through all the discovery, come visit with your client, and we'll have an announcement next time whether or not it's going to be worked out or it needs to be. Okay. Thank you. Yes, sir. Jose Lopez Pamias? Yes. And Mr. Pamias' case trial to begin with jury selection next Monday, and the state has filed a motion for continuance. Mr. Coleman is a special prosecutor, specially set for sentencing part of that trial next week. Is that correct? Ms. Perazo, what is your position?
Your Honor, of course, I'm going to just continue my has been incarcerated. There is some time, with multiple times. I was in convention, but we're ready to see.
Okay. Well, it's not at that point yet. I am going to grant the motion for continuance. Obviously, because Mr. Pamias is in custody, I will do my best to try to get it reset as quickly as we can. Obviously, it's an old case, and he's in custody, so I'll do the best we can to get it tried as quickly as possible. Thank you. You can go back with the pen. Morning. Are you Kevin Harmon? And good morning, Ms. Holmes. Will your client waive the formal reading of the indictment? Mr. Harmon, in cause number 24, DCCR 1612, you are charged with a second-degree felony offense of assault of a peace officer from July 9th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? Yeah, please. And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? We got state tenders number 1. It's admitted. Is there any evidence that Mr. Harmon is not clear? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case to the probation department to do a pre-sentence report. And that'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
Okay.
They didn't file the cases, and then I don't know that I can. Where are you going to live when you get out, Mr. Harmon? I cannot understand you. Right. But that's where all this happened? No, this is a different place. So if I let you out today, I want to, what's the name of the friends that you're saying that you're going to live with? Say it again. Harley? Iron? How you spell it? Gotcha. Last name Woods? Okay. So at least while this is pending, if I let you out today, I'm ordering that you live with them, not at the other place where all of this happened. Okay? Maybe later, if everything's going well and you want to have some relationship with whoever this was, I'll get more information about that. Please finish report. We can talk about it again. But what I'm going to do today, because of your plea for probation, I'm going to reduce your bond in your case to $1,000. So if you're able to make that bond, there's a couple of things that are very important. First thing is that if you make the bond, you go directly to the probation office. They can start that interview process for your plea son. If you don't go there and do that, then you run the risk of me not accepting the plea agreement and sticking with what you understand. Also, a condition of that bond is that you are going to live with Iron Woods. No one else until I give you permission or we discuss it again. Do you understand? Also, if you are arrested, you make that bond and you're arrested, and before you come back, it's the same obviously. Okay? All right. See you soon. Thank you, Mr. Good morning. Are you Katrina Swan? And Ms. Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing is the truth, the whole truth, and nothing but the truth?
Welcome back to Courtroom Chronicles. Today we're diving into a tense morning docket, multiple defendants, heavy charges, and some real human moments that remind us how justice isn't always black and white. Keep your eyes open. You're about to see judges juggling fairness, frustration, and the fine print of Texas law.
Thank you. Your hand down in this Holmes for your client waiting for the reading of the motion. One, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th, 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March 2025. Is that true or not true? True or not? True. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th, 2025. Is that true or not true? Count 3 alleges that you failed to participate in the mental health services, follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true? And then count 7 alleges that you're behind in your court of fees. Is that true or not true? All right, did you enter your pleas of true to counts 1 through 7, freely and voluntarily? And did you plead true to those counts because they're all actually? All right, then I'm going to find that you entered your pleas of true to counts 1 through 7, freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. It's my understanding that the probation department are willing to give you a chance to go to the special needs safety program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on probation. I want to make sure you understand this is your second chance now, and you will not get a third. You are on probation for first-degree felony. Today, right now, I can send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life. It's violating probation on this type of law. So you need to take advantage of everything that they teach you, because when you get out of safety, you'll have aftercare, you'll have people to help you, find places to live, and all of that. But it's going to be up to you to take advantage of those things. Do you understand? All right. I'm also going to, because you didn't report, because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and in court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years. But it will take you getting everything in line real quick and doing everything right. Understand? All right, good luck to you, ma'am. You go back with the bailiff. We're going to get some paperwork for you to sign about safety. You need to sign that when they go and give it to you. Good morning, sir. You Brontez Williams. And Ms. Holmes, will your client waive the formal reading of the indictment? Mr. Williams, in clause number 22-40090, you're charged with a third-degree felony offense of fraudulent use of identifying information from January 20th of 2022. How do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you? I have here on the computer some documents that have your signature on them. Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Yeah. She has to hear you too over here, all right? They're taking everything down. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization of the federal? State tenders number 1. It's admitted. Is there any evidence that Mr. Williams is not? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. It shows this was an agreement that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to us. All right? Good luck to you, sir. You can go back with the data. Okay, are you Laddie Johnson? And Mr. Parker, will your client waive the formal reading of the indictment? Mr. Johnson, in clause number 24, DCCR 2388, the state has elected to proceed on count 1 only, and in that count to the lesser included offense with Class A misdemeanor resisting arrest, and that's from October 24th of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Here's the tension. The defense wants to move forward. The client's been waiting behind bars. But the state's lead prosecutor booked solid. When a motion for continuance hits, it's basically a legal delay button. Sometimes necessary, sometimes devastating. Especially when the defendant's been waiting months just to get their day in court.
And are you a U.S. citizen? State tenders number 1. It's admitted. Is there any evidence that Mr. Johnson is not competent? Mr. Johnson, I'm going to find that you entered the plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of resisting arrest. Sentence you in accordance with that agreement to a term of 200 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Y'all have already got the 200 days, so y'all confirm that. So it looks like you have 200 days credit, and so you should be... So you're getting 200 days, and you have 200 days. Okay. Okay. All right, so I'm handing you the trial court certification. It shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. Good morning. Are you Stephanie Moore? And Miss Moore is on probation for robbery. There's a motion to revoke. And what's
She was due to tell the court what she's been doing before we waited on conviction. That's it. And she's not doing that.
Paul Rohan?
I spoke with before she told me she didn't have to go off the last meeting. She would like to tell the court where she was not on.
I didn't ask this for just to, I did not about the next year, in my box. He'll get any kind of the house. In 19, when I just got showing up to lose that relationship, I didn't know that television show. Realized that I could get my driver's license. You know, I have to take care of my past and she's past. And he was like thinking that I asked him, I wrote over in the company. He's working behind us and probably he shot me off. He shot back a little bit. The way she is and the way we live down now. The way that nothing that she was able to do. When I did probably in the chat before we got to the house. There was my friend. So last time he had like this cop. Laying down in the neighborhood, and talk to him, and so I didn't just listen, and I knew that I was taking one of it for me with you, which is timely, so that I want to live a normal life, have a license, not have a job, and have a home, and mortgage, and land, and 48, so about 48 years old, I just wanted to not have a job there.
so, I mean,
She was on
No, I wasn't thinking. No, I did it when I was right.
She was on her back and coming. I think it was on 12 of that.
hold on. So, here's what I would say we do. The only thing I would know to do is go through the motion, get an updated report that would include substance abuse assessment, where we are now, more information about all of that, and then we can see what our options are. I mean, the motion has been holding it open, and so I can. The motion's holding it open, and I don't know that I can do it because we're past 2011. Since 2011. I guess what I would like to do as part of that update is for the probation department to give us whatever options there are extended. Now, I do know I could convict, do a straight probation, I think would be an option. I don't know. So let's, if you want to do that, talk to her about it. Yeah, y'all visit, and then we can just go through the motion, get the police true or not true, let probation do a more detailed visit, figure out what's been going on and where, maybe confirm some of those things, and then we can see what our options are when we come back for sentencing. It's all I need to do. All right. Sure. Okay. So to visit with her, if y'all want to do that, we could go through the motion today, and then we'll see where we are. Are you Michaelan Jones? And Mr. Rojas, for your client, waive the formal reading of the motion. Mr. Jones, in cause number 22-39715, I have a motion to revoke your...
Notice how the judge is methodically walking the defendant through every right and consequence. That's called a plea colloquy. It's like a verbal checklist to make sure no one can later say, I didn't know what I was agreeing to. Every yes, ma'am, and yes, sir matters here. One wrong answer could derail the plea deal entirely.
Okay. Thank you. I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct? And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point in Louisiana. Is that true or not true? True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point, Louisiana. And is that true or not true? And then count 4 alleges that you committed the offense of possession of a Schedule 1 drug on May 17th of 2023, also in the parish of Point-Coupé, Louisiana. Is that true or not true? Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily? Did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rowe? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
Okay.
It's admitted. Is there any evidence Mr. Jones is not competent?
Hold on.
Sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Oh. So the motion is on based on
You did.
Yeah, that authority.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion, which is just a month or so, or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, there wasn't a full place for some reason. And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will we'll get that done. Okay? All right, so Mr. Jones, I am handing you the trial court certification. Well, 2 things. One, showing that this was an agreement, so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rowe. All right, good luck to you, sir. Thank you, probation, for being here. Good morning, you're Crystal Moore. All right, y'all give me just a second to... So there's a motion to revoke probation in 23 DCCR 202, and there's no bond in that one, correct?
Correct.
And then in 25 DCCR 0496, oh no, you're not asking for that one.
No.
So really, we're just talking about the other one.
Okay.
So, on probation for DWI with a child passenger, and the new offense is theft, correct? State jail felony.
You also the rest of the control substance.
Okay. probably waiting on lapse on that. And that's the same date as the theft, or is that something different? Do you know? Okay.
Both of them. Oh, bullshit.
Okay, that's okay. So I want to make sure, and Mr. Coleman has filed a response, and part of that response includes the information that Ms. Moore was previously convicted of offensive robbery, initially placed on a deferred probation that was revoked in 2017 on that case. Also, a conviction for aggravated assault on Tarrant County from 2017. And then we've got the probation that was granted here on the driving while intoxicated with a child passenger, while on this probation has been arrested for 2 new offenses, theft and the possession of a controlled substance. Yeah, that I see that as well. And there, do you know if there's warrants issued for that? I know it's hard to get information. Do you know anything about that? Alright. Mr. Rojas, do you wish to call any witnesses? Ms. Moore, best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing to be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Would you cooperate or? Why not?
Speak up for us.
How many kids? What are the range of? Is she the only one, the only dog at home? That's one of the do you have any income when you're not in jail? What do you have? You have to fight. Courthouse. How often? Do you have bank account? Do you have an idea how much money? You own probably. Is your mother or anything? You're on board. That's present. You can involve. You got something to do. Not. Yes. You got to not.
This is one of those moments that gives you chills. The judge reminding her that she could legally send her to prison for the rest of her life. But instead, she offers treatment and another shot at redemption. It's tough love in action. Accountability meets compassion. The real question, will she take it?
Also, the question, say I vote out the 14.
I'm looking back, just everyone, for the record, at the pre-sentence report that was prepared in clause number 23, 2026, and I reviewed that. Also reviewed there's a handful of jail incident reports that everyone was given a copy of as well. Based on the nature of Ms. Moore's prior convictions, which range from beginning as a juvenile, back in 06 and 7, extending all the way through 2012 as a juvenile, assault, theft, violation of court orders, and then we get into adults, and we've got more theft, county jail theft property, then we get into felony, robbery, given a probation not revoked, assault of theft from a person, and then we've got an aggravated assault with a deadly weapon from Tarrant County. Now on probation, given all the opportunities, multiple allegations in the motion to revoke probation, that Ms. Moore has not apparently done much of anything while on probation to get the help that we've been offering her. In addition to having 2 new offenses, possession and another theft, I find that it is in the best interest of our community that there not be a bond in clause 23 DCCR 202. I appreciate the arguments, and I feel and have empathy for what you're going through, but you should have thought about that before you kept doing what you were doing. So we can go back with the bailiff. I'll set the case for an announcement on the motion. All right, so are you Sadog Wilson? Ma'am, I'm sorry. I was looking at the sound this way and not at you. Seidel? Okay. And Mr. Rojas, will your client waive the formal reading of the motion? All right, Ms. Wilson, in clause number 22-40450, I have a first amended motion to revoke your unadjudicated probation. This
is heartbreaking. A woman caught in the cycle of abuse, trying to explain 7 lost years. The legal system often meets stories like this with cold paperwork. But listen closely. Behind every motion to revoke is a human being who sometimes just ran out of safe options.
That you were placed on probation February 27th of 2024 for the offense of burglary at a habitation, and that was a 5-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. Is that true or not true? True. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Listen, hold on. Thank you. Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true? True. Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true? And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. Is that true or not? True. Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily? And did you? It's okay. It's all right. You're good. Did you enter those pleas of truth freely and voluntarily? And did you plead true to those counts because they're actually? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rowe? And do you fully understand? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving, giving up any right to appeal? State tenders number 1. It's admitted. Is there any evidence that Ms. Wilson is not competent? Alright, ma'am, I'm going to find that you entered the pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can. Good luck to you, ma'am.